Thank you so much for joining us and for remaining with us. Now, wills are meant to bring clarity, but sometimes the clauses within them, especially the restrictive ones, can spark confusion, disputes, and even legal battles among beneficiaries, which in most cases are children. Now, how do you balance the original intent of the person making the will with the rights of those inheriting the estate, especially when, as you heard, can be conflicting sometimes? Today, we have experts from First Trustees to help us navigate this delicate and often misunderstood area of estate planning, estate intent, and estate beneficiary rights. Thank you so much for joining us this morning, Mr. Rotimi Obende, Head Private Trust, First Trustees. We appreciate your time today.
Thank you. It's a pleasure to be back one more time.
So let's begin with context. Now, what are those things that you call restrictive clauses in wills, and why do people include them?
Okay, so there are two ways to look at it. One is preventive, and the other is conditional. And so I'm thinking, and somebody is saying to me that I have these assets, and you can only, for example, use these assets if you still bear my name. Or, as my children, you're only allowed to enjoy the benefit of these assets without necessarily owning them. So just in case you are wondering, over the past 1-2 weeks, maybe less, the social media or internet has been agog with Iwanyanwu's Chief Iwanyanwu's will. And you see a restrictive or conditional clause placed there when it comes to how much enjoyment and for what period the wife can enjoy the assets that he left behind. And so, like I said to some people a few days ago, you can just wake up and become a celebrity because somebody in his wisdom sat down and said, you will enjoy all of these assets as long as you decide not to remarry. That's a restrictive conditional clause that an individual has placed there. The question is, why did he do it? I do not know. I cannot answer for him. He alone knows the reason why he decided to include that clause.
And unfortunately, he is no longer here to answer that question.
Which is one of the setbacks of having a will, because a will only comes into effect until after the demise of the testator. What is also critical, and based on what you just asked, is the fact that there was also then no explanation for his decision. So it's now left us to start to guess. So maybe it's because he wants the assets preserved for his family, or maybe because he doesn't want another man to come and enjoy the resources that he's worked for. All of these are guesses, and we can never ever know because the intentions were not stated.
So how do these restrictive clauses sometimes come into conflict with the rights of the beneficiaries?
Okay, so I'll just still leave it at that story, the Chief Iwanyanwu's story. So you have a young lady who, for intent and purpose, many of us didn't know, but all of a sudden, like I said, you are out there, maybe you now have 2 million followers and all of that, trying to find out, or you've then left a lot of us analyzing the situation. Now, what has been done is to say, I'm not saying you cannot remarry, although a lot of people assume or presume he has said don't remarry. That's not what he said. He just simply said that if you are going to remarry, then you will lose the benefit of these assets that I have freely given to you to enjoy. No, so in a way, you are basically preventing her from remarrying if she wants to continue to enjoy those benefits. But if she doesn't want to continue to enjoy those benefits, then she can then decide to go and remarry. That's caging, in my own opinion, caging that particular individual. But then there are other things that people... So when people put restrictive clauses, it's a way of preventing beneficiaries from enjoying the benefits that they are supposed to enjoy. But on the other side, it's also an opportunity to try and create some form of you're trying to then manage your portfolio such that those who are not beneficiaries don't enjoy the benefit. So it's in two ways. It's preventing the individual from trying to do one or two things with their lives. When you say, okay, if you then decide to marry, for example, you are just going to stop enjoying the benefit. But if you look at it, some other clauses which are also preventive is used trying to stop people from contesting the will in a way. Yeah.
So now, okay, so let's talk about solutions. Because we could go on and on about this one, because I don't think this is justiciable. It is a will. And I don't know if the restrictive clauses are justiciable or not, but please don't answer that one. So let's talk about solutions. So how can someone drafting a will ensure their wishes are respected without unfairly restricting or harming their beneficiaries?
So I would rather look at it from the beneficiaries themselves, from that perspective. And so both of us know that many times the other gender think that his assets or his wealth or his money is our money. Then my own money is my money. But in this particular case, you see that it is not. And so many times they make that mistake and then don't plan for themselves. So I say to myself and I say to people that the beneficiaries themselves need to start to think about planning for themselves. For example, when it comes to will, it's just very difficult because it's something that does not come into effect. And it's the intention of the testator, that's the writer of the will, to say, this is what I want to do, and this is how I want to do it. Now, it's for beneficiaries themselves to then, in quote, be in good behavior. And so when people start to write their wills, I also would say that when people start to write their wills, you don't leave gaps. Because if you ask me, there are a lot of gaps in that particular clause itself. If I tell you one of those gaps, so what's marriage, for example? What does it mean for her to be married?
I'm the one asking the questions.
The other question is, if you check many of these footballers or professional athletes, what do? They just have partners, and they then enjoy whatever benefits there are. So you can always find gaps. So for me, I would say that beneficiaries need to take care of themselves, have proper plans and proper solutions. Now, for writers of wills, you need to also think about some other instruments. Wills are not enough, and we keep saying it, in terms of you wanting to plan your estate. You need to also think about other instruments that are private and confidential, because a will is a public document. It's been read in the open. Maybe when the will was read, there were only 5, 10, 7 people in the room. But I can tell you today that the number of people that have this information is maybe like more than 5 million, 10 million, or even 20 million. But you can make this thing private and confidential by exploring other estate planning tools, particularly trust. Trust is private and confidential. I bet you that only 1 or 2 people would have known if that clause was in a trust arrangement rather than in a will that then becomes a public document.
But the trust comes into effect even before the...
Oh, yeah. So in the lifetime of the creator of the trust comes into being, and that's why we talk about a living trust. What is also then important, if a trust had been adopted rather than a will, you would have just made her and other children beneficiaries. You are not owners, so you continue to enjoy the benefit. And the benefit can then be outside real estate. You then have all other forms of investment. There could have even been monthly allowances, whether for children or for spouse or whoever, communities. So those are important things that people need to also consider. The fact that you can use a trust to balance the life of your family members. Like I said, everything is out in the open. You've just put the woman, your wife, in a very uncomfortable position because everybody now knows that the day she decides to get married, she loses all the benefits. But in a trust arrangement, Not me. I will not know. You will not know. The 20, 30, 40 million people who have read the will or based on what has happened on social media would also not have known and should have continued to live a life in a very comfortable manner.
Well, since we are talking about will today, what advice would you give to anyone currently drafting or updating their will to avoid, such conflicts?
Okay, so number one, I would say you need to use a professional. And what that simply means is that a professional that would look at all the gaps. I pointed, for example, a gap that if anybody wants to exploit, would basically exploit that gap. And what is that gap? Yes, they say I should not remarry. Okay, no problem. I will not change my name. I will not change my status, which is marriage anyway. And it's not going to even be official. But it doesn't then stop me from doing whatever it is that I want to do while still continuing to enjoy the benefit. If I want to have children, I can have children. So you need to speak with a professional. You need a professional to help you draft your estate planning document such that all of these gaps can't be taken care of when it comes to whether you are writing your will. So if you're writing your will at this time, or you're thinking of writing your will or updating your will, you need to be speaking with the right kind of professional. Now, a second thing when you speak to a professional is some of these clauses are not supposed to be seen as punishment. There should be ways where you reward people outside saying that you lose benefit if you do this, or if you do this, or if you do that. There are ways you can put incentives in place, ensure that people have achievable goals. And once they achieve those goals, they can then enjoy the benefits of the estate. So those are things I believe that people should be looking at, whether you're thinking of writing your will or whether you're thinking of updating your will. It's important that you look at all of these perspectives.
But you also talked about options. Do you think it's a good time to also consider those options?
Oh, yes. This is the best time, if you've written your will, best time to think and put a trust in place. Again, for confidentiality purposes. Again, to ensure that you've not just damaged, in quotes, the life of beneficiaries. So, for example, so if it's flipped the other way and she was given maybe 500 million or 3 billion or 5 billion, you've also just then put her in a very uncomfortable position because people now know that, this person has 5 billion. So this is the best time to start to think of other options. And trust, for me, is the best way to go. There are also tax benefits if you decide to go with a trust. So it's confidential. There are tax benefits attached to going with a trust. And your wishes will then be followed to the latter.
And then you can even monitor it while you're still alive.
Oh, yes. That's a very important point to highlight. The fact that in your lifetime, a trust kicks in. A trust can help you. So you can even make changes. If you see that this person is well behaved, you can add incentives. So, for example, they said that 70% of the proceeds of a particular property should be used for the education of a beneficiary. A trust would have simply set funds aside. So imagine if they don't get probate or they are not able to sell the property for the next 5 years, how does that child go to school? How is the education of that child taken care of? Will the child then wait till the property is sold? No. So with a trust in place, you can make all of those provisions available such that the education of that child is not stopped, the welfare of that child is not stopped. If there are then medical needs, the trust can simply take care of the medical needs of that particular child. He doesn't need to wait. Now, if the child is a minor, then you are then looking at who's going to be the guardian of that child. If the money comes to the guardian, are you sure that the guardian will use it for the benefit of that child? We're talking dollars, we're talking pounds. So it's important. Have a trust in place, managed by an institution, First Trustees, by the way, and you're sure that First Trustees will do every single thing that you have in your trust arrangement.
Can anyone watching you right now convert a will to a trust?
There's no need to convert a will to a trust. A will is a good document, but a trust is an added estate planning instrument. So what you should be looking at and asking Rotimi, can I use the two? And I'll say to you, yes, you can use the two. Move your assets, depending on the nature of the assets that you have in your will, to your trust. Let both of them run side by side. However, your will just be in limbo, because then there's really nothing that is going to happen until the person has passed. But you can then monitor your trust. You can make investments from your trust. You can earn good returns on your trust assets, such that those returns can even take care of you during your lifetime. A trust can help you with all investment purposes, whether it's investing in cash-related assets or liquid assets, or it's helping you to invest in euro bonds or all forms of investment. Then even in acquisition, asset acquisition, whether it's land or properties, or even in business holdings. So if you want to buy, for example, a First Bank shares, your trust can help you acquire a First Bank shares.
Okay, well, I hope that you haven't answered this question, but I'm going to ask it anyway.
Okay.
So how does First Trustees support clients in balancing personal wishes with the evolving realities and needs of their beneficiaries?
Okay, so I spoke about a professional, and clearly First Trustee stands in that particular place. We can help you draft your will. We can help you with clauses that are not punitive, with clauses that do not prevent, to a large extent, the other person living his life or her life. We can then also help you create a trust arrangement. That trust can take care of your family needs, take care of your investment needs, take care of the educational needs of your children, and ensure eventually that when you then pass on, maybe in another 20, 30, or 40 years, you are paying minimal estate taxes or inheritance taxes, and your beneficiaries can live a comfortable life without being exposed to the public.
Well, that's a good one. I hope there is a way that people can contact you.
Oh, yeah. So the easiest way would be to call us on 08054 000 or you follow us at any of our social medias at First Trustees.
At First Trustees. Okay, the number again, just in case.
08054 000
0054299.
Correct.
Okay. Thank you so much for your time this morning.
Thank you.
Mr. Rotimi Obende is Head Private Trust of First Trustees. We appreciate your time this morning.
Thank you very much, sir.
Okay. So the next conversation, I don't know whether it has anything to do with a will or a trust, but maybe the word trust is hanging there somewhere. We'll find out in this conversation.